Um, a second issue that I think is particularly problematic for small businesses is that while this agency is purported as necessary to protect businesses from particularly financial institutions and financial products, the scope of its regulatory authority would stretch well beyond financial institutions. There's actually two primary provisions that could potentially bring in small businesses that really don't have anything to do with finance into this new regulatory regime. The first is basically the way that they try to trigger who would be a regulated entity under the Consumer Financial Protection Agency is by defining financial activity. And basically anybody that's engaged in financial activity would then be regulated. But the definition of financial activity is so broad. It actually includes simply the extension of credit. But the extension of credit under the bill is defined as any time that you allow your customers to pay in 4 or more installments or in which there's a finance charge imposed. So when you think about particularly small businesses at the local level, if you give your customers any sort of flexibility to pay over time, whether you're a local merchant, whether you're some types of general contractors like plumbers, electricians, certain medical professionals like dentists, orthodontists that let their parents pay for their kids' dentist braces over time, these types of transactions would be directly regulated and bring those small businesses under that regulatory umbrella. A second way that they really reach into a broader domain of the economy is any company, any business that provides a material service to a financial firm would also be directly regulated like a financial firm. So if you offer advertising, marketing services to one of the financial firms, if you're providing technology, software providers, data processing, data storage, lawyers, in fact, would even be directly regulated by this agency. So the point is, the scope of this agency is basically so broad that there's actually very little segments of the business community that they wouldn't be able to reach into at some point. So that's really our second primary.
Is the direction of the U.S. Chamber's philosophy to oppose the creation of the Bureau at all, or to try to modify it via amendments that would address some of the issues that you're bringing up?
At this point, I think we would have preferred to see an alternative structure altogether. We actually, and I can get into that, but we proposed a council of regulators that's responsible for holding each other accountable to protect consumers rather than a new agency. But I think that this bill is certainly going to happen, and it's a high priority that they have an independent bureau or agency. So at this point, I think what we're really trying to do is push for either amendments or hopefully to get senators to ask for these changes before the bill even gets to the floor. I think that would be the ideal. So, ultimately, then we would like to narrow the scope just to financial institutions. The third primary concern that we have is, this is supposed to be a new federal standard, basically out of concern that in certain states consumers weren't protected to the degree that they should have been, and that there is, varying degrees of consumer protection even among the regulators at the federal level. But unfortunately, rather than establish a uniform national standard, the bill would actually allow states to continue to pass their own consumer protection laws. So there isn't full federal preemption. Even for nationally chartered banks that have had federal preemption for over 150 years. To go even further than that, they actually give state AGs the ability to enforce the new federal standard based upon their own interpretation. So when you think about the world of sort of the regulatory regime that is consumer protection, you would have this new federal standard. You'd have states that can continue to pass their own and varying consumer protection laws, and then you have state AGs that are enforcing their own interpretation. So it's basically this idea that we were streamlining, that we were going to reduce the confusion in terms of what consumers can see by protection, what companies have to do to comply with these new rules. It's actually made much worse by this scenario. So in that degree, I think we need to have full preemption of state law, and state AG shouldn't be able to enforce this new federal standard based upon their own interpretation. One of the significant concerns from the broader business community about the state AG provision is that they can actually outsource these enforcement suits to the trial bar on a contingency fee basis. So the incentive is really there to rope in any of the businesses that could be potentially brought in based on the very broad authority of this new regulator. And the fourth concern that we have is really sort of a fundamental question of how we actually want to regulate our financial institutions. Particularly on the heels of a near financial meltdown, we want our regulators to make sure that they have a very comprehensive view of the health and stability of each financial institution. But this proposal would actually extract regulation of the products that these institutions are offering from those that are responsible to make sure that our depository institutions are safe and sound. And so we think that that's actually bifurcating two goals that are really inextricable. So in that regard, particularly when you take into account the fact that the director of this new agency would ultimately be able to move unilaterally, even if the safety and soundness regulators were to find that a regulation could potentially threaten the stability of the system, there's no meaningful way to block that rule.